So I have three introductory points before I start. The first is to identify the aims of the session. Really, to show you that EU law is a system like any other law. It has rules. EU law starts with a code, the treaties, and then to that it adds case law. But it is fundamentally a case law-driven system. It isn't a system anyone needs to have any concerns about in terms of competence to deal with. It's very similar to a common law system. Although it does start with a code, but then in employment law, for example, in English law, essentially you also start with a code, and then you add the case law to it. And so we're looking at something which should be familiar. And what I want to do is to cover where EU law comes from, or where, if I might call it. Secondly, what effect it has on English law, on national law. And thirdly, how one might obtain clarification of the meaning of a provision of EU law as and when necessary. The second introductory point, why am I learning this? Can I doze off for the next 50 minutes? In short, no. Right from the very beginning of any civil litigation, there is a prospect of the potential of some EU law point to come up. If one thinks in a jurisdiction context, has the English court got jurisdiction to deal with this matter? In general civil cases, it's now Regulation 44 of 2001. It happens in family law. There are similar parallel provisions for determining the jurisdiction of the English court to deal with a child abduction, to deal with a divorce or a matrimonial property case. And also in insolvency. At the moment, one reads in the newspapers about Irish businessmen engaging in what's colloquially called bankruptcy tourism. Coming to England because after 1 year in England as a bankrupt, they are apparently discharged, whereas it might take 12 years in Ireland. And also, I'm dealing with a case at the moment in Bournemouth, in the Bournemouth County Court, which is bankruptcy tourism at a very large scale. A German from Erfurt came to England to be adjudged bankrupt here because the rules are less strict than Germany. So, jurisdiction, the very first step. And also, many of the substantive law areas have been strongly influenced by EU law. I give several examples. In point 8 of the handout on page 5, employment, consumer protection, product liability is entirely an EU code. What's being passed around is the hard copy of the handout. I think many of you have it already. Environmental law, motor insurance, company law, competition, obviously. And so there are many and varied areas where EU law comes up. And often, in an area where you think EU law might come up, the advocate may not draw your attention to the fact that there is an EU directive which underlies the relevant law. And don't hesitate to ask, because as I'll show you, even if English law has implemented the underlying obligation from EU law, the EU directive is still relevant to interpret the UK provision. And to give you a practical hands-on example, a few years ago, about 7 or 8 years ago, I was instructed to go to Barrow and Furness County Court in a case arising out of milk quotas. And there we had a district judge who had never come across, he told me later, never come across a point of EU law. He listened, he took it on board, and he gave a judgment which was actually rather better than many higher courts have given and would give in similar circumstances. So there is no magic about EU law or its content. The last introductory point is, I think it's if you have the handout, just the source of EU law in English law is page 9 of the annexes to my handout. You've got an extract from the European Communities Act, and section 2.1 on page 10 is the important provision. Essentially, all such rights, powers, liabilities, obligations and restrictions created under the treaties are without further enactment to be given legal effect or used in the United Kingdom, should be recognised and available in law and be enforced, allowed and followed accordingly. That's the sort of all-embracing provision which brings in the treaties and all the treaties have with them, the case law and the secondary legislation, into English law. So that's why we're here. My first major topic is what is EU law, in a sense, where it comes from, and to that I'll go to my first two headings on the handout, the sources of law. Now, we have the treaties, what I referred to earlier as the code, if you like. There used to be only a single treaty, the EC Treaty, which is relevant, but since the Lisbon Treaty, there are now two treaties which are relevant. That's the Treaty on European Union, this is page 1 of my handout, and the Treaty on the Functioning of the European Union. The TEU is the more sort of overall, overarching document, the umbrella document. One might risk being politically incorrect, the sort of more constitutional-like document. Whereas the second treaty is much more the mechanics of how EU law works. There is, as I say on the handout on page 1, an additional critical document, which has also recently come in, the Charter of Fundamental Rights, which essentially applies the Convention on Human Rights as part of EU law and does a little more besides, and we'll come back to that in due course. Just to give you a bit of a flavour, I thought it might help for us to look for a few minutes at some of the annexes. If we start on page 13, just to show you the nature of the provisions that you'll see if you're looking at a treaty. And I've taken a few extracts from both treaties, but I start with, on page 13, with some extracts from the Treaty on European Union. And these are right at the beginning, Article 4. So Article 4.1, in accordance with Article 5, competence is not conferred upon the Union and the treaties remain with Member States. But then 4.3, very important, particularly the second sentence I shall read, the Member State shall take any appropriate measure, general or particular, to ensure fulfilment of the obligations arising out of the treaties or resulting from the acts and institutions of the Union. That's an obligation directly incumbent on not only Member States, but also the courts of Member States, and therefore on you. Article 5, if I can point perhaps to 5.3, under the principle of subsidiarity in areas which do not fall within its exclusive competence, the Union shall act only if and insofar as the objectives of the proposed action can be sufficiently achieved by the Member States. So the EU does not act unless the Member States cannot sufficiently achieve the relevant aim. Article 6.1 is the article which incorporates the Charter and gives legal effect to the Charter. And then 6.3 is important. Fundamental rights, either from the Convention on Human Rights, or, secondly, this is important, as they result from the constitutional traditions common to the Member States, shall constitute general principles of the Union's law. And I'm going to come back in a moment, because the general principles of law is a very important source of EU law. The Article 51 at the bottom of page 14, the protocols and annexes to the treaties shall form an integral part thereof. And so there are various annexes and quite a lot of protocols which are also part of the treaties. I can then go forward. Page 15, just note Article 47. Everyone whose rights and freedoms guaranteed by the law of the Union are violated has the right to an effective remedy before a tribunal in compliance with the conditions laid down in this article. So that's essentially the court's job, to provide an effective remedy for any breach or violation of the rights. And then I think I'm just trying to take it in an introductory way. Perhaps I can move to page 17. Note Article 18. Within the scope of application of the treaties, and I'll leave out that, any discrimination on grounds of nationality shall be prohibited. It's one of the major cornerstones of EU law. And then Article 34, further down the page, quantitative restrictions on imports and all measures having equivalent effect shall be prohibited in the Member States. So what Member States can't do is to say we'll only accept 10,000 cars from France this year, or any measure which is equivalent to that. So it gives one perhaps a slight flavour. If I can turn forward then to the article, just to show you two articles which I think are particularly relevant to you. There's page 25, Article 267. And this is my third major topic, how to obtain clarification. And I'll come back to it in due course. But this is the provision in Article 267 at the bottom of page 25, which shows you it's the jurisdiction for the European Court of Justice to provide clarification on points of on the meaning of issues of EU law. And I'll come back to that. Then page 26 really brings us Article 288, brings us to the next source of EU law after the treaties. The next source is secondary legislation. If you like, in UK parliaments, we talk about statutory instruments. In the EU parliaments, we talk about specifically 3 provisions, and they're listed in Article 288. They're the regulations, directives, and decisions. I leave off the non-legally binding ones, the recommendations and opinions. But so regulations, directives, and decisions. These are 3 types of, if you like, secondary legislation. What is a regulation? Regulation is something which applies immediately. So if one likes, in Barrow and Furness County Court, milk quotas is governed by an EU code set out in a regulation. And that's something which is applicable in the same way as an Act of Parliament, the same way as a statutory instrument. It doesn't need any implementation by member states, and indeed implementation by member states is generally discouraged because it can change the meaning of the regulation. But the majority of EU law, with which we'd probably be dealing with, is to be found in directives, and that's the 3rd subparagraph of Article 288. A directive shall be binding as the result to be achieved upon each member state which it is addressed, but shall leave to the national authorities the choice of form and methods. And then a decision shall be binding in its entirety. So what does a directive do? It tells the member state what to do, and so the member state then introduces either an Act of Parliament or a statutory instrument to implement the directive. But as I'll be showing you, the directive still remains important as a source of the meaning of what the member state, or the English law, if you like, what the English law would mean if it applies a directive. I think perhaps just to give you a bit of flavour, to bring it alive a little more, I'll see whether I can work this to show you just where to find, because very often when one comes across references to a directive, Council may not provide you with the copy of the relevant directive. Now, there's a site, it's on the handout, it's called Eurelex, and it provides free access to all EU law. And it's very simple. Down the left-hand column, you've got a simple search. If I provide search by document number, you can search there for any regulation, directive, or decision. And so if I take something, it's a directive or a regulation I've used a lot. Say, sorry, they entered the year 2003. And then I go down 1783. I know that. So there's a regulation on the bottom, and you can go and you can bring up a PDF of the regulation. And so there you've got the regulation. There is also, if I can just go back a screen, a provision. This is a regulation which has been amended a lot, and so I'll go back to new search. This keypad will allow me, this mouse pad will allow me. A useful thing is in consolidated text, because consolidated text, I go back to the same regulation, 1783, and then that should be yes, it's a regulation which it shows you on the first page, corrected by, and then it gives a corrigendum. And if I can just close that down again, another useful thing in EU law, and not necessarily for you to do, but there should be, in many instances, where there's something which, a provision, a regulation, or a directive which is unclear, one thing which the European Court tells us is to look at other language versions. And there's no excuse for not doing it, because over across on the right, you can just choose the language. So if we go for French, I'm sorry, that's English again. I'm not suggesting you necessarily do this, but you know that if you're aware it's there, so you've got the same regulation in French. You see it in a couple of seconds. And then you can go down and you can check it. And it's something which, you just need to ask people. And you do get some judges who will ask. And you get people, so people are debating a point of the finer points of the meaning of an and or an or the meaning of a particular provision. Is it shall, is it mandatory, or is it not? And then you look in a few other linguistic versions, and even if you've got very little, because you can look, obviously in languages you're good at, you can look at better, but it's just useful as an aid to the interpretation without taking too far. While I'm at the computer, if I can just also show you, for recent case law, the Court of Justice itself, on its own website, it's called Curia, it's also on the handout. So you choose the language, English, and then you've got a case search. This is really something which, listening to Stephen's exposition on IT law yesterday, these are free sites, and really they possibly could be, these two sites, Eurelex and Curia, could be up on the portal for the judges. So case number, because it's much easier with a case number, because then you're certain that you've got the right case. This is a case which was decided in December last year. And you've got you can get the judgment in this case, which was a refugee case on reference from the Court of Appeal, England and Wales. And so it's decided, I think, if I remember rightly, 21st December. And you can go straight through normally. That looks a little slow. But you can go straight through to the text. We don't necessarily need to wait for that. I suspect that might be the network here. So the sources, the treaties are also available obviously on the Eurelex site. So you've got the treaties there. You've got the directives, the regulations. Decisions tend to be something which are party specific. So EXCO is fined €500,000 for running a cartel in the transport of widgets between France and Germany and Austria or something like that. So that's a decision is used for something very specific, and you're much less likely to come across decisions in practice. Yes, it's still, I must say that's it's normally a very well-run site, and I suspect that might be the network here rather. It's there, yeah. So, but I mean, it's just to show you that rather, as Stephen was explaining last night, you've got these things really at the click of a button. So have council, and so there's no harm in asking them, because this is not rocket science. It's simply that knowledge of where to find these sources might be somewhat limited. The other aspect of sources of law, as I've said, I mentioned this earlier, it's point 3 on my handout, fundamental principles of law. And this is something which shows you that really community law, EU law, is a common law system. Because all the important stuff is not to be found in the treaties, although sometimes some of these principles have now been put into the treaties. But they were found, discovered, as we like to say, and in some way, and principles of common law, they were discovered in the common constitutional traditions of the member states. And if I can just mention, I give a list of some of the principles. But if you take the principle, for example, of non-discrimination, and I can only briefly skate over them for the purposes of this talk, but it's a principle which applies generally, not just as non-discrimination on grounds of nationality, but if you have, for example, differential treatment of farmers for access to subsidies, depending on whether they live within a certain radius of the holding. There was a Finnish case about this. Finnish case where they were trying to encourage farmers to live close to the holding, and so they gave them extra subsidies to farm in the tough areas in the north of Finland, and yet you got absent farmers in Helsinki who were wanting to apply for the same aids. And they said, well, we're discriminated against because although we live in the city, we still manage farms up in the north of Finland. And that raises issues of non-discrimination. It's quite a powerful tool. But the second principle I mentioned is proportionality, something you probably come across in relation to human rights. You look, it's very similar sort of analysis. You look at, first of all, the critical thing in proportionality is what is the public policy objective pursued That's something which is quite frequently neglected. You have to identify that objective, because it's only, you test the measures concerned as to whether they are proportionate by reference to that public policy objective, and you examine whether the measures are limited to what is necessary. The third one I mention also came up, I think, at dinner last night, legal certainty. It's a powerful tool, more powerful in continental civilian codes than in English law traditionally, although one of those powerful statements of legal certainty comes from Lord Diplock in the Black Clawson case in 1975, that before committing himself to any action, the citizen should be able to know in advance what are the legal consequences which flow from that action. And so examining rules of law to see whether they are sufficiently clear, or examining an injunction to see whether it's sufficiently clear to form the basis of committal. That sort of thing. And I know that Stephen's been wrestling with that recently. And each of these principles of law, each of these general principles, and there are many more, and I give at the end references to textbooks which might help you if ever you need to grapple with them. In particular, on these general principles, Takis Tridimas, Don in London, has written a whole book on these general principles. But they are essentially the principles of administrative law. So it's, if you like, the parallel book to De Smith for the EU lawyer. And each of these principles is applicable as an aid to the interpretation of EU law or the national implementing legislation. And it's also, they are also capable of forming the basis of review on the grounds of illegality of EU legislation. But it's very important that it's appreciated that the general principles of law supplement the written texts. They supplement the written text. This is a point frequently neglected by administrative authorities. So, for example, I do quite a lot of EU law related, applied to agriculture, and DEFRA, or the Rural Payments Agency in Reading, when they're reading a regulation, they read the regulation, but they read it without reference to these general principles, because they're not stated there. They are simply the underlying principles of law, the same way as we have. They're part, if you like, of the common law of the EU. And so I took a case, it's on the handout, Fisher, Mr. Fisher, to the Court of Justice in 2000. That was somebody who needed to declare to the RPA the previous cropping history of the farm where he had just become the new tenant. He couldn't, because the previous tenant had had a nervous breakdown and wasn't speaking to anybody about anything. And Mr. Fisher asked MAF for the cropping history, and MAF said, well, we can't give you that, it's protected by data protection. And so they penalised him for when he guessed and got it wrong. He guessed on the way he examined the land and tried to work out what had been grown on the land and got it wrong. And the European Court said, well, first of all, you should have disclosed this information to him. Data protection, the exceptions would have permitted disclosure. But secondly, if you don't give him the means to protect himself, then, if you like, on grounds of rights of defence, what you can't do is penalise him later. And so it is something, the application of these general principles is neglected. The Charter, really, I can't, time sort of restricts me from saying much about it, but essentially the Charter of Fundamental Rights, it incorporates the Convention on Human Rights into EU law. And it's the sort of the base position under EU law is that the protection given for rights under the Charter will be at least the same as those given by Strasbourg. And there are difficult issues to come over which is the top dog in terms of the Constitutional Court for Europe. Is it Strasbourg? Is it Luxembourg? But those for another day. My second major topic is what effect EU law has on English law or on any national system. It's really points 4, 5 and 6 for that. Point 4 is how you interpret EU law. I think it's quite an old case, Silfit, going back to 1982. There's an extract in your bundle at page 47. In particular, I shall turn straight to page 51, as you see some indications of the approach to interpretation of provisions of community law. And this is still cited regularly for the courts. It's a good, solid basis for the sort of approach one might take. Without the facts don't really concern us for today. Paragraph 17. it's relating to the facts of the case. The existence of such a possibility must be assessed on the basis of the characteristic features of community law, the particular difficulties to which its interpretation gives rise, and then makes, I think, one might say 4 points. To begin with, the legislation is drafted in several languages, and different language versions are all equally authentic. And so an interpretation of a provision of community law thus involves a comparison of the different language versions. Although in practice, even the court itself doesn't go to 20-odd languages. They tend to go to the main languages and look and see where there are differences. And when you're looking for a difference, if there is to be a difference, the Romance languages normally follow the same line, so you're unlikely to see a difference between French, Spanish, and Italian, because the translators probably look at those versions and compare. The difference will come between those languages and either English or German. So because they're the main language version. So if you're looking for a difference, that's where you'll tend to find it. The sort of fault line between sort of more Nordic languages, so Dutch, German, English, and the Romance languages on the other hand. Secondly, must be brought.
Is there any pecking order of languages?
There's no pecking order. No, it's still that they are all equally authentic. That's the principle. And you do get cases where, I mean, and I'll go on to the way in which one approaches interpretation. The purpose and context is the most important element of interpretation. But you can find cases, and I've seen cases, where there was one isolated version which seemed to be out of step with the rest. But when you looked at the context and purpose, it was that version which was the correct one, and the other ones incorporated. So it isn't a question either of weighing the balance. Well, here you've got 10 languages for one and 2 languages for the other. The two might be correct. Must be borne in mind, even where the different language versions are entirely in accord, community law uses terminology which is peculiar to it. This is paragraph 19. Thirdly, furthermore, it must be emphasised that legal concepts do not necessarily have the same meaning in community law and in the law of the various member states. And so the fact that you see something which that I know, because that's a concept I know under English law, of course would be perhaps a dangerous approach. Paragraph 20, finally, every provision of community law must be placed in its context. And personally, as somebody who's practiced law for many years, I think that is the most important thing. I mean, context is a bit, in community law, it's broader. It's a sort of approach which Lord Mance took in the Supreme Court in the case I did called Bloomsbury Fishing. It's about paragraph 19 of the judgment. It's a judgment of June last year. But context is critical because, as Lord Mance points out in that case, context can change everything. So a word which might be totally familiar in a separate context might have a different meaning. And context really in community law is a bit like throwing a stone into a pond. That you've got the ripples, you've got the immediate ripple, which is the article in which you find it, which is found. Then you've got the part of the directive, and then you've got the directive as a whole with its recitals, and then you've got perhaps the other directives on a similar subject, and then you've got the treaty provisions. And so it's a bit like looking to see what purpose that provision was designed to serve in the system itself. And I do think that the Supreme Court at the moment is moving more towards that approach in terms of, particularly in the public law cases, is moving more towards that purposive way. And the Bloomsbury case, I think, is a good example. And so perhaps the difference between English and EU interpretations perhaps diminishing. Just a short reference, page 57, to see perhaps a particularly, the facts again don't need to concern us, a particularly list of the way in which the court, this is the Court of First Instance, the General Court, it's on page 57, and I'm taking this out of context consciously, but time doesn't permit to give you the context, and I'm not sure it really helps. But just to see, in that top paragraph, just before, there's a long list of, there's a list of 2 or 3 cases there, just before the end of the top paragraph. The case law requires that point 6.2 of the guidelines must be interpreted literally, that's the black letter, historically, that's the travaux préparatoires, looking back to the way in which the provision came to be, contextually, that's what I've just been referring to as the ripples and the pond, and teleologically, that's the purpose it was designed to achieve. And the purpose is elicited essentially from the recitals to the relevant provision. So a directive at the beginning always has a list of recitals, whereas firstly, whereas secondly, whereas thirdly, and so on and so forth. And they frequently give you a good idea of the purpose of the provision. So, and that purpose and context, there are cases, it's on the handout, the Grad case is an example. I mean, if one had to the time of inclination, I should have said when I was going to, in terms of research, for case law, the Courier site, which I showed you for the case law there, has all recent case law from about 1997. But on the Eurolex site, you have all case law of the Court of Justice back to 1953, or I think that's when it started. But what you do need for all case law is the case number. So when I searched for that case, I searched for case C 411 of 2000 stroke 10. You need that case number, and all the textbooks give you the case number, and that's the easy way to search for the case law. I think from there, that's the headlines of interpretation of the EU provisions. But point 5 on my handout, how does EU law affect English law? And this is, I think, perhaps the most important bit of the lecture for you. Once you've got the sources, and once you're looking at, how's it going to be practical? How's it going to be useful for me? How am I going to apply it? It's the Marleasing case is the seminal case in this field. And basically what Marleasing tries to do is to explain how you as a national judge use EU law to interpret the national provisions. And I think it might help just to go to Marleasing. It's page 63 of the handout, and this was in the page clip also handed around by Patience a few minutes ago. And I'll start on page 63. It's an extract with the headings back on page 61. And it's a case that came from Spain. It was a case about the validity of the formation of a company. And essentially, just by way of brief background, in order for the formation of a company to be valid under Spanish law, you had to have essentially consideration. You had to have cause. Anthony can explain to you at the coffee break more what cause means, but there's some equivalence. It's not the same, but some equivalence between the idea of cause and the idea of consideration under English law. So it's a really deep-rooted principle of Spanish law, which went back at least as far as the first Spanish Civil Code. Page 63, at the bottom of the page, it's apparent from the grounds set out in the order for reference that Marleasing's primary claim, based on the Spanish Civil Code, according to which contracts without cause or whose cause is unlawful have no legal effect, is for a declaration that the founder's contract establishing the other part of the litigation, la comercial, is void on the ground that the establishment of the company lacked cause, was a sham transaction, was carried out in order to defraud the creditors of Barbiesa. But La Comercial answers, contending that the action should be dismissed in its entirety on the ground, in particular, that Article 11 of this directive lists exhaustively the cases on which the nullity of a company may be ordered. And lack of cause is not among those lists. So you have a directive saying the constitution of a company may be unlawful on grounds A to Z, and A to Z don't include lack of cause. At the bottom of the page, paragraph 7, it's apparent from the documents before the court that the National Court seeks in substance to ascertain whether a National Court hearing a case which falls within the scope of the directive is required to interpret its national law in the light of the wording and purpose of that directive in order to preclude a declaration of nullity of a public limited company on a ground other than those listed in Article 11 of the directive. So if one imagines Spanish law, in effect, says, well, there are these grounds A to Z, and then there's ground, an additional ground at the bottom of this list, which is lack of cause. And then the important paragraph is paragraph unnumbered. It's the first one on page 60, first full paragraph on page 65. In order to reply to the question, should be observed that, as the court pointed out in von Coulson, the member states' obligations arising from a directive to achieve the result envisaged by the directive, and their duty under Article 5 to take all appropriate measures, whether general or particular, to ensure fulfilment of that obligation, is binding on all authorities, including for matters within their jurisdiction, the courts. It therefore follows, in applying national law, whether the provisions in question were adopted before or after the directive. So the directive bites on all existing national law and all national law designed to implement the directive. The National Court called upon to interpret it is required to do so as far as possible in the light of the wording and purpose of the directive in order to achieve the result pursued by the latter and thereby comply with the third paragraph of the reference there. The paragraph numbers have changed. It's now 288 of the treaty, and I showed you that earlier. That's the provision which talks about regulations, directives and decisions and explains what they are. And so the next paragraph, it follows that the requirement that national law must be interpreted in conformity with Article 11 of the directive precludes the interpretation of provisions of national law relating to public limited companies in such a manner that the nullity of a public limited company may be ordered on grounds other than those exhaustively listed in Article 11 of the directive in question. So essentially reading down national law where necessary. Okay? And then I'm going to give two examples, and you've got them in the bundle, just to show you how this works, how it pans out in practice. The first example is Lidster, session of the House of Lords of, it's in the bundle. It starts at page 66. This involved the transfer of undertakings regulations, which, as some of you may know, implemented an EU directive. And the opening words of the head note, page 66, show you that the receivers, company receivership, the second sentence, the receivers agreed to sell the business asset to the transferee, and 1 hour before the transfer took place, the workforce were told by the receivers that the business was to close down and that they were dismissed with immediate effect. It's 1 hour before the transfer, and the transfer of undertakings, if they were still employed at the moment of transfer, would have protected the employment rights of those employees and passed them on to the transferee. The Industrial Tribunal concluded that the applicants had been employed by the transferor on the business immediately before the transfer to the transferee, within the meaning of the relevant regulation, because I think the terms were employed immediately before, or would have been so employed if not. I'm sorry, I'm jumping ahead. I'll just come on to that. In the head note, the held, allowing the appeal, is because the Court of Session had said that these guys sacked 1 hour before transfer were not employed immediately before transfer, allowing the appeal that the regulations of 1981 were expressly enacted for the purpose of complying with the relevant directive, which provides for the safeguarding of employees' rights on the transfer of their business. Secondly, that the courts of the UK were under a duty to give a purposive construction of the regulations in a manner which would accord with the decisions of the European Court of Justice on the directive, and where necessary, implying words which would achieve that effect. Thirdly, and this is sort of guidance I think it gives us, because it shows what it may be necessary to do, that there had to be implied into Regulation 5.3, after the words immediately before the transfer, the words or would have been so employed if he had not been unfairly dismissed in the circumstances described by Regulation 8.1. So it's implying words to give effect to the purpose. And I'll just take you briefly in the judgment of Lord Templeman. It's the relevant passage on page 71. It starts at E, having recited the Principum von Coulson, which, interestingly, of course, this case was a year or so before the Marleasing decision. So it may have been a number of months, but I think it was about a year before. And so this case was, in fact, adopting the approach which the European Court itself subsequently adopted. So it shows, in a sense, the orthodoxy of it. But the courts, it's that passage E to H. I won't read it, but you'll see, perhaps particularly at G, seems to me, following the suggestion of Lord Keith, that paragraph 5.3 was not intended, or not to be construed so as to limit the operation of Regulation 5 to persons employed immediately before transfer in point of time, must be construed on the footing that it applies to a person employed immediately before the transfer, or who would have been so employed if he had not been unfairly dismissed before the transfer for a reason connected with the transfer. So it's trying to give an effective protection to the rights guaranteed by the directive. That's my first example. My second example is the AutoLogic case, and you would be entirely forgiven for thinking that you may not be dealing with the intricacies of group relief in corporation tax in the county court, and so I won't go to the facts of the case, but AutoLogic, it's in the bundle. I'll just go to pages 79 to 80, because you see there 2 paragraphs in Lord Nicholl's speech, when this was a case about whether the group relief provisions were contrary to EU law, And Lord Nichols, at this point in the judgment, just recalling basic principles, says, well, what would be the position if this argument were correct, if there were an incompatibility with EU law for this basic provision of English corporate taxation. So the second basic principle at paragraph 16 concerns the interpretation and application of UK legislation which is inconsistent with a directly applicable provision of community law. Where such an inconsistency exists, the statutory provision is to be read and take effect as though the statute had enacted the offending provision that had enacted the offending provision was to be without prejudice the directly enforceable community rights of persons having the benefit of such rights. So that, although not written into the statute, it's as if every provision of English law, which is contrary to provision of EU law, you read it as being the provision in English law, it is to be read as if without prejudice to the directly effective provisions or directly applicable provisions of EU law. Paragraph 17 adds to this. It's particularly the sentence just below B, after the reference to the Simmental case. Accordingly, if an inconsistency with directly enforceable community law exists, formal statutory requirements must, where necessary, be disapplied or moulded to the extent needed to enable those requirements to be applied in a manner consistent with community law. So very much what comes out of that Mar-leasing case, disapplied or moulded. So in Mar-leasing, it was a disapplication, but the Spanish law effectively had an additional ground of nullity for a company, and you had to disapply that. So that's, and I really do stress this interpretive obligation. I mean, it was stressed, the reference on the handout, Gaidan Mendoza, in point 5 of the handout. It's the same sort of idea which arises under the Human Rights Act. The primary remedy is this moulding, disapplying where necessary, the moulding of English law in order to comply with the provisions of community law. And just by way of guidance as to how far that obligation applies, obviously you've got Litster, you've got autologic, and in Guida Mendoza, it was Lord Steyn noted that English lawyers can tend to apply law in too literal and technical a way, with too much emphasis on linguistic features, and that where there is incompatibility, there should be a broader approach so as not to undermine the purpose of the relevant provisions. A short note, I'll take it fairly shortly, point 6, direct effect and validity of national law. There can be circumstances where a member state does not implement a directive. One takes, for example, in the insurance sector, between 1975 and 2001, the UK did not apply the EU insurance directives to Lloyd's of London. Although the insurance directives apply to all insurance undertakings throughout the EU, some policy decision was taken somewhere, and these directives were not applied for that period to Lloyd's of London. In those circumstances, where you have a member state failing to take action in accordance with the directive, or possibly misapplying a directive, so misimplementing, trying to implement a directive but making a mistake, can the member state, when it's trying to enforce national law which is incompatible with EU law, can the member state rely on national provisions without regard to its commitment under the treaties to implement directives? And the answer is, where the member state is a party to litigation, then the other party to litigation, the member state interpreted broadly to include any emanation of the state, such as a local authority, such as certain universities, such as certain privatised undertakings if they have special powers. So the member state, in its broad sense, cannot deny the relevance or deny the force of the relevant directives. It's perhaps less likely to come to you, so I deal with it briefly, but on page 5 of my handout, there are 3 conditions to be satisfied for direct effect to be, and it's towards the top of the handout, for direct effect to be available. The content provisions must be clear and precise. There must not be any discretion, and also the provision must be sufficiently conditional. And I've taken that very briefly because I think it's prospect of it coming up maybe fairly low in your practice. So I turn to point 7, and this is why it's important. Point 7 is why it's important for courts to be astute in being able to interpret English law in accordance with the relevant provisions of EU law. It's because point 7 of my handout just points out that in the final analysis, if it is not possible to interpret English law in accordance with EU law, or it's not possible to provide direct effect, then there may be a residual liability and damages of the member state. It's a form of damages for breach of statutory duty. The breach of statutory duty, in a sense, and I'm using that term loosely, it's not in an English law sense, the breach of statutory duty is the failure to apply the treaties, to give full force and effect to the treaties. There are 3 conditions, and they're fairly searching conditions. Does the rule of law infringed intend to confer rights on individuals? Secondly, is there a direct causal link between the breach of EU law and the damage suffered? And thirdly, is the breach of EU law sufficiently serious? Just to be aware of. But if you are interested, then Byrne and the MIB is the last case in the annexes, and Lord Justice Carnworth gives a step-by-step analysis. And it's really for you to read in your own time if you were interested, or if you had a case raising an EU point, just to see the approach, how a common lawyer gets to grips. And it's a model approach, if I may say so, of the approach of English court to dealing with principles which may not be instantly familiar. So I turn to my third major topic. How might one obtain clarification if a provision of EU law is really not sufficiently clear? It's point 9 of my handout, references for preliminary ruling. And this is reference preliminary ruling. Basically, the English court asks a question to the European Court of Justice, a question on the interpretation of EU law, asks the European Court of Justice for a view, and then the answer comes back. I mean, I think it finds. I was reading a book on European legal history recently, and I came across a practice from the 15th, 16th centuries in Germany called Aktenversendung. Apparently, the German judges at that sort of period, when they didn't know what the answer to a difficult case was, they used to tie up the papers with string and send them off to the university, the local university, and say, "Dear Mr. Professors, we can't see the answer to this in the current legal provisions. Can you help?" And then the answer would come back as to what the judge should do, and then the judge would hand down his judgment. And there seems a certain parallel between that and the provision for the European Court of Justice, although before the European Court of Justice, fortunately, one has a right to appear normally, although some of the judges would prefer that to be abolished so that they could deal with the cases more speedily, a question which the bar is resisting strenuously. But can I just turn back to the article of the treaty, which is the governing provision. It's page 25 of the annexes, Article 267. Article 267 at the bottom of page 25. The Court of Justice of the European Union shall have jurisdiction to give preliminary rulings concerning the interpretation of the treaties, and B, the validity and interpretation of acts of the institutions, bodies, offices or agencies of the Union. Essentially, to include all regulations, decisions, directives, and the treaties. The second subparagraph is the paragraph which would concern you, if this point were put to you. And I would add that Barrow and Furness County Court, on my milk quota case, could have referred. The district judge could have referred. He decided himself, but he could have referred it. And certainly in the past, magistrates' courts have referred issues to Luxembourg in relation to Sunday trading. I'm not encouraging it, but I'm saying the jurisdiction is there if it's necessary to use it. Where such a question is raised before any court or tribunal of a member state, that court or tribunal may, that's the may, I stress may, that's a discretion, if it considers that a decision on the question is necessary, that's the jurisdictional issue, which must be the jurisdictional threshold to be crossed. Is it necessary? Is a decision on the question necessary to enable it to give judgment? Request the court to give a ruling thereon. The distinction between the discretion and the jurisdictional threshold of necessary is sometimes difficult to draw in practice. And while you're there, you might also notice the final paragraph, but that's only for courts of last resort. So courts against whose decisions there is no judicial remedy, there's an obligation to bring the matter before the Court of Justice unless the matter is very clear. Now, whether a reference is necessary. And there, back to my handout on page 6. For lower courts or tribunals, when is a reference necessary? It's Lord Bingham, in his various positions, first of all, the first instance in a case called Samex, and then in the Court of Appeal, Sir Thomas Bingham, particularly in the Elsa case, which I cite on the handout, if the facts have been found, and that may include working on the basis of agreed facts, if there's sufficient agreement on the facts, and the EU issue is critical, and then what Sir Thomas Bingham said in that case, the appropriate course is ordinarily to refer the issue to the Court of Justice unless the National Court can, with complete confidence, resolve the issue itself. A formulation which looks rather in favour of references, although in fact, as I say in the next bullet point, the complete confidence test has been applied somewhat loosely, with the result sometimes that reasoning of the English court in certain cases has later been, in inverted commas, overturned or shown to be not in accordance with EU law in later cases by the Court of Justice. Notice that as an English judge, as a judge, you must consider this of your own motion. It's not something where you have to say, well, as there's no application, I can't make a reference. That's not the position. This is something, it's a facility to aid judges. Sometimes there will be an application, and sometimes it may be proper to reject that application. But sometimes there may be no application, and it may be proper to consider making a reference. I've made the point it's courts of whatever level. Perhaps an important issue is the EU issue truly critical to the decision? And what one sees, for example, I don't think it's on the handout, but in the Country Landowners Association in 2006, the House of Lords had to consider the validity of the hunting ban. And one of the issues raised was an EU issue on free movement of services. And there was some debate and lack of clarity about the meaning of the free movement of services point. But the way in which the House of Lords dealt with the matter in that case was they said, well, even if we assume that there is a restriction on the free movement of services, we have to look to see whether that restriction is justified in the circumstances of this case. Now, the Court of Justice would never give a view as to whether the restriction under national law is justified in the individual circumstances of the case. And so the House of Lords were putting on one side the difficult point of EU law, assuming that in favour of the claimants, and then saying, well, we have to apply, even assuming that's right, and that would be referable to the Court of Justice, we have to determine justification. We have to determine whether this restriction is justified in the individual case. So, and in terms of the factors which the court may need to take into account, it's the factors are referred to in the else case, towards the bottom of page 6 of my handout. The general importance of the point, the court best fitted to decide the point. And Sir Thomas Bingham noted the position of the Court of Justice, able to receive submissions from the European Commission, able to receive submissions from other member states. Will a higher court refer it? If you take my milk quota case from Barry and Furness, had that case is a sort of case which may have gone much higher, quite a lot of money was at stake. It may be that you may save money, and that was a point made by Mr. Justice Bingham in the Samex case, an earlier case, 1983, that there may be, if a case is going to go from first instance to the Court of Appeal in any event, and it is the EU law issue which is truly critical, it may actually save money by going straight to the Court of Justice. And the time of a Court of Appeal to the Court of Justice, or the time of going to the Court of Appeal, the time of going to the Court of Justice, has been comparable. The Court of Appeal possibly now slightly quicker, because both courts have become more efficient. And so, obviously, there will be expense and delay, but it may be more expensive to let it go up through the established channels in the courts. And I don't think I need to deal with courts of national resort, because it may be some time before you arrive to that exalted position. And so, I think just coming to the end of my time, and I've put some summaries. In fact, I noticed on my further reading I missed off a chapter which I contributed to in Supperstone, Gowdy and Walker. We did a chapter there, Sir Richard Pender and I did a chapter there, it's Supperstone, Gowdy and Walker on Judicial Review, the 4th edition. It's a blue textbook on administrative law. We did a single chapter there on EU law, and so that's a sort of reasonable EU law in one chapter approach. But it is a legal system like any other. It has rules, they are easily accessible, and the thing is, sometimes you may need to scratch the surface and to dig a little behind council submissions in likely areas, and I've listed some of those on the handout, to find out whether you need to go and apply some EU law. So I'm happy to take any questions that you have.
Well, I think we'd probably better draw close to you. Could I just add to what you said? Don't think this won't from time to time happen, because I've had cross-jurisdictional claims, I've had motor insurance issues which have reference to the directives. There is a lot of work going on in Europe about pan-European contract law, which we've had an input in. And if some of you ever get to sit or do sit in the administrative court regularly, planning decisions and the like have to have involvement with the directives. So from time to time it will come in, and I thank you very much, because this has given you a good overview and a handy crib for the future, so at least you've got some idea of where to look and what to do. Thank you very much.